A very good morning, everyone, and welcome to the second in our series of three virtual seminar events that we're running during January and February on the defined benefit, or DB, pensions and advice market. Thank you again for registering for this. We hope that you're well. We're very excited to be running these events, having run a similar series back in May 2020 at the height of the first lockdown. Thanks again if you listened to those or gave us some feedback. We really appreciate it. Thanks for tuning in last week. The DB pension advice market continues to be the subject of a lot of scrutiny, a lot of change. So yes, we're sort of reconvening and running this fresh series of webinars for 2022. I'm Peter Lovegrove, and my colleague Rebecca Prestige and I both work in Grant Thornton's regulatory advisory practice. Hello again, Rebecca. How are you today?
Morning, Peter. I'm very well. You?
Yes, not too bad. Thank you. Not too bad. Rebecca and I are both pension transfer specialists, and our team's done a lot of work over the past 2 to 3 years with firms and other industry parties on various aspects of defined benefit pension transfer advice. Forgive me as I go through the sort of usual logistical and housekeeping points. So this is a virtual event, it's being recorded, and we will distribute it to everyone that registered for this event as soon as we can afterwards. And as usual, you'd expect me to apologise in advance for any unexpected interruptions. We're recording this remotely. There might be certain disruptions that are out of our control, so please do forgive us if that happens. As I said last week, we are actually planning to do an in-person workshop of this type at our offices in Finsbury Square in London as soon as we can. Hopefully that's becoming more feasible now. So before we get stuck into today's session, let's just briefly signpost what we're doing across these three events, which started last Wednesday and are going on today and next week, all at the same time between 10 and 11. So last Wednesday, Rebecca and I talked about the current state of the DB pension advice market and the outlook for this year in the context of issues surrounding advice given to members of the British Steel pension scheme, and indeed the ongoing impact of the more recent changes to the FCA's rules and guidance. Today, we're going to talk about the FCA's own defined benefit advice assessment tool, the snappily named DBAT. We've got a lot of experience of using that tool for either giving live advice or indeed reviewing past advice. So that's going to be the subject matter for today's session. And then next Wednesday, the 9th of February, we're going to look at our views on the key components of a compliant, high quality piece of DB pension advice, including in what scenarios is a transfer more or less likely to be appropriate and why, and what's the FCA's views on all of that. So each week, Rebecca and I have a conversation to explore these topics. Today, I have to say, is likely to be more of Rebecca guiding us through the DBAT, but we'd love you to participate as well. So if you've got any questions you'd like to ask, please do submit them via the chat function, and we'll do our best to address those either as we go or at the end of the session. We've also got a couple of instant poll questions earlier on in the session, so please do participate in those as well. Great. Okay, so yes, last week Rebecca and I talked about some of the more recent changes to the DB advice market, including the rule changes brought in by the FCA in October 2020 and the effect that it had. So that included the new concept of abridged advice, the effective ban, apart from in certain circumstances, on contingent charging, and the requirement to consider a workplace scheme as a transfer destination. We also spent a bit of time talking about the FCA's DSEO letter sent in December last year, which signposted a consultation on a Section 404 redress scheme for members of the British Steel pension scheme who were advised to transfer out within a certain period. We discussed the possible implications of that for firms, one of which would be the requirement for firms to review any advice given to BSPS members to transfer out within that prescribed time period of March 17 to March 18. As we mentioned, we understand the FCA is gathering more information, more evidence. It's engaging with stakeholders, and it expects to consult on this by the end of March. In the meantime, though, we think it's a great idea for firms to try and get on the front foot, if they haven't done so already, take a proactive approach to reviewing any advice they've given to DB scheme members, particularly British Steel members, but anyone really. This would be to gain comfort that the advice you provided was sound, but also to signal to the FCA that you are being proactive, you do take responsibilities to customers and the potential risk of any detriment very seriously. So before we get going, in that vein, can we start with a quick poll question? So yes, we're going to ask you, thinking about your firm that you're representing today, have you provided defined benefit pension transfer advice to clients in the past? So 4 possible answers to this. Yes, and we have started or finished reviewing that advice. Yes, but we haven't reviewed any of that advice. No, we don't have any such clients, or not applicable, not sure. So if you could just spend a few moments answering that question, that'd be really helpful to set the scene for today.
Thank you, Peter. Yeah, it'll be interesting to see whether many people today have actually sort of given advice in this area and are planning to review it if they haven't already.
So we'll give it a little bit longer. We do always very much appreciate people taking part in these. It's really helpful.
Yeah, well, it helps to inform, you know, what we might cover in the future as well, doesn't it?
Very much so. Here we go. Wow, interesting. So, nearly 3/4 of our respondents say yes, we have started or indeed finished reviewing some or all of this advice. 15%, 16% rather say yes, but we haven't started to review the advice. Nobody who's responded says we don't have any DB pension transfer clients, which is reassuring given the subject matter of these sessions. And just over 1 in 10 say not sure, not applicable to them. What do you make of that, Rebecca?
Yeah, interested. You know, we talked about firms trying to get on the front foot. It seems, as you say, nearly 3/4 are on the front foot and are sort of proactive in this area, which is good to see.
Very reassuring. Excellent. Good. Thank you everyone again for participating in that. That's really helpful. It's a good scene setter. So yes, we thought it'd be helpful today to spend some time actually going through the FCA's own defined benefit advice assessment tool, the much vaunted DBAT. So we're going to explain the approach that we think the FCA wants firms to take. And we'll share some insights from our own experience of using this tool, which we've got quite a lot. We think actually is pretty good, don't we, when, for either reviewing past advice or indeed sense checking real-time live advice. So Rebecca, before I hand over for you to run a tutorial for us on this, let's just do one more quick poll question for those listening to this today, which is very simply, have you used the DBAT tool yourselves in practice for any reason? Yes, you have, no, you haven't, or this is all new to me. So again, really helpful to set the scene if everyone can answer that question. Helps us to pitch this as we go through. I'm really interested in this, Rebecca, actually. We know they published this. They published this a year or so ago, didn't they? It's been interesting to see. Again, this is anecdotal and a bit unscientific, but a straw poll of how widely it is actually used out there in practice by firms is really interesting.
Well, and given that, you know, nearly 3/4 of the participants on this call have started to review advice, it will be interesting to see if they're using the DBAT. Yep.
I can say it is worth noting that you don't have to use this. There's no rule that says you must.
Yeah, and actually, I think with some firms, you don't even need to use all of the tools, so you could sort of use it as a bit of a checklist or a ready recno, and might be that some are partially using it.
Here we go.
Interesting. Okay.
Interesting. So just under half say they have used the DBAT for any reason. 39% no, and 14% not come across the tool before. Interesting. So that's a pretty good split.
Yeah, interesting. And you know, hopefully then it looks as though a session on sort of talking through the DBAT might be quite useful, certainly for those who haven't used it at all, and perhaps for those who haven't started reviewing advice yet.
Absolutely, good. Right, so Rebecca, over to you. I will chip in with what I hope are vaguely intelligent questions here and there, but over to you. I mean, you have used this tool so extensively, so I think everyone will be useful for everyone for you to talk them through it.
Yeah, no, please do chip in, otherwise people will probably get bored of listening to my voice for the next however long. But yes, as you said, we have used this tool quite extensively, and the tool was, I think, designed to assist firms when reviewing past DB pension transfer advice, but it does also cater for firms who want to give live real-time advice, and we have actually used that with clients, sort of assessing advice that's sort of in process or in progress, as we call it. And I think some firms also are looking to maybe use it as a bit of a compliance checklist type thing, as I mentioned, a bit of a pro forma to assess sort of advice given by their front lines. As we've said, we've used it extensively in both scenarios, and pretty much I think we believe it works quite well. I think it takes a bit of getting used to. It takes a bit. I mean, it takes a bit of sort of practice, I think, and it can be quite a lengthy process. But we have sort of gained speed as we've used it over time. The FCA has said that it will be publishing a new version of the DBAT, which will take account of abridged advice. And I think there might be some other sort of additions to some of the tabs. And I think they're sort of taking some feedback from industry on certain things that could perhaps work a bit better. So we do await the new one, but in the meantime, as we said last week, the current one we feel is fit for purpose. It does the job. You might sort of have to bear in mind a few other things when it comes to sort of abridged advice or potential workplace pension schemes as a receiving scheme, but pretty much on the whole it works. So essentially it consists of an Excel spreadsheet which records all of the details of the case. There's quite a few tabs in that spreadsheet, but essentially it's Excel, and there is an extensive and quite comprehensive instructions manual. So the FCA has really provided quite a lot of detail. I think it runs to about nearly 100 pages, so there is an awful lot of detail in there. But it's quite procedural, and the steps sort of seem to follow on from each other. And if you take a bit of time to go through the manual whilst filling out the DBAT, I think it will pay dividends in the long run.
I mean, I think that manual for practitioners who do this a lot, that manual is sort of largely codified common sense, isn't it?
It is.
For giving this kind of advice.
Yeah, it really is, and it's sort of a Bible really to this advice. And I think if you follow the instructions, in the Bible as we call it, you should, as we said, you should be able to give this advice well and be able to document that you've given it well.
Yeah.
So as I said, it's an Excel spreadsheet, and it's made up of 6 assessment tabs, and each tab requires the reviewer or an advisor to undertake a series of steps. The tool itself is quite interactive, she says, for an Excel tool, and there are different tabs or different parts within each tab that sort of get switched on or off depending on information that's put in. So for example, once you put in the date of advice, that will either sort of turn on and sort of shade on sort of the relevant TVAS or TBC section, and it will sort of blank out the irrelevant section. So as you go through, the tool itself should indicate what fields need to be completed, and it should be fairly clear which ones are not relevant because they sort of get greyed out. What we like about the tool, I think most of all, as I said, there are 6 sort of tabs, but what it really does is it separates out the component parts of the advice process. So when we've reviewed advice in the past, we can sort of get quite a lot of unclear ratings, or we see reviewers getting a bit of a tangle over sort of some process hurdles that have not been sort of jumped over, whilst not really sort of assessing what the outcome of the transfer was. So it splits out all the different component parts, and it's an outcome focused review. So what we're really looking at is splitting out what the advisor should have done in terms of COBS rules, and then actually what the advice was and what it did for the client, and whether it was the right thing for that client or not.
I think that's really important, isn't it? We've all experienced this. You look at a piece of advice and you think, well, I can see where the advisor was going here, and it makes sense to me. But this is missing, or that paragraph in the suitability report is a bit misleading. So separating the bits out and assessing them differently is helpful.
It does. It really is helpful. And I know we've been using this tool now for well over a year, sort of 2 years or whatever. And certainly when some of our reviewers came to look at this in the first place, they were looking at files and thinking, this isn't a perfect file, there's no way this advice can be suitable. Whereas what we sort of have to get our heads around, that we're not looking for perfect files, we're looking for, what was the outcome for the client, and was it the right thing, notwithstanding, that there were some errors or omissions by the advisor. It's worth pointing out that the tool won't make an automatic assessment of suitability. So whilst it will turn on sort of boxes and come to a determination, sort of a cursory determination, is actually for the reviewer to decide. And what it does, it will support the reviewer to identify the key information on the file and consider whether there is enough information to make an assessment of suitability in terms of both the pension transfer and any associated investment advice. So that's sort of the first thing that the tool does. It enables the reviewer to decide whether or not they can go ahead and make an assessment. And then where there is enough information, it will support the making of the suitability assessment. And then what it does is it directs the reviewer to sort of capture and reference the evidence upon which the assessment has been made. So it's quite procedural, as I said, and we sort of go through the steps, and it does make quite a bit of sense as you go through, but it takes a bit of time and a bit of practice. So I think we can move on to the next slide, please, Emma. That's it, thank you, or Layla. So the very first tab is the information tab. So anybody who's come across the DBAT will have stumbled upon this tab first and foremost. And essentially this tab is for the reviewer to make an assessment about whether or not the firm has obtained the essential facts about the client to enable it to make a recommendation that's suitable for that client. So this is sort of one of the fundamental rules about having enough information to go ahead and give a recommendation in the first place. Arguably, we think this is the most difficult and time-consuming tab of all to complete, which might sound a bit counterintuitive, and we do know that some sort of firms think this is just sort of an information, gathering exercise of just sort of putting in information, but actually it does require quite a lot of subjectivity, and it will require a reviewer to be really looking at the case in the round when completing this tab. This tab captures all client information and will allow spouse or partner information to be captured. Interestingly, and I think guidance from the FCA is, even if advice is given on a sole basis and said to be given on a sole life basis, where a client is married and certainly where finances are sort of intertwined, then we will be assessing advice as joint, which will mean that we would probably need information about the spouse to be on file, or certainly we might need information in order to sort of be able to go ahead and assess suitability.
Yeah. We found, haven't we, that factoring in the whole household's assets and liabilities can be quite transformative. Yes. When you think about advice, it can change the picture completely.
It can.
Something which looked not good for the client can look fine for the client when you factor in assets held by a spouse or partner.
Yeah, absolutely, it can. And as we all know, the client isn't the only one that benefits from a DB scheme, and there are other beneficiaries which need to be taken into account. And this tool lends itself to really take into account everybody that's affected by the DB scheme. It's important to note when we're going through these, so the first tab has got sort of 10 information sections. A couple of them are slightly more straightforward than others. But essentially, the question for each area is asking whether or not the firm has obtained the necessary information. So this is where sometimes it's knowing the case as a whole, will allow you to determine whether or not necessary information has been captured or not. So, you know, sometimes we might have information around financial situation, and we might think, oh, there's quite a lot missing there. But actually, if it really has no bearing on the advice, because perhaps, for example, I don't know, somebody hasn't got the right attitude to transfer risk, or the financial situation of the spouse is really important, then, you know, sometimes there'll be missing information, but it's not necessary to make the assessment, in which case we don't need to have it. So when we're answering the questions on the tool, we're not answering whether or not all of the information is there. We're asking whether or not all the necessary information is there, and it's quite a crucial point. And actually is the thing that we sort of end up having case clinics and dilemmas about most of the time, really. As I said, it captures basic sort of health information, dependence and vulnerability details. It then goes on to capture information around objectives and financial situation, and it's normally on sort of objectives or financial situation information that a case will sort of stand or fall. And the more sort of you know, colour and detail we can see there will help when determining suitability. We've then got sections on attitude to risk, attitude to transfer risk, capacity for loss, and knowledge and experience. And again, where we're answering yes or no to these sort of sections, we're answering whether or not the firm has captured it. So, for example, if we're saying we could have a client that has got no knowledge of investments or pensions or transfers, they've got very little or no experience, but if the firm has captured that, then we'll be answering, you know, that as a yes. So the firm has captured, for example, that the client doesn't have any knowledge and experience. Similarly with attitude to transfer risk. So whilst this wasn't an explicit requirement before 2018, it was implicit throughout the advice process that the advisor should be establishing what the client's attitude to, you know, giving up safeguarded benefits might be in exchange for a sort of flexible environment. So those are really quite important. And in fact, some of capturing information there can sometimes, as I said, sort of make or break a case. So it could be that, you know, the transfer seems like the right thing to do, the customer can afford it, there's no real reliance on income, but if actually fundamentally they haven't got the right attitude to transfer risk, it may well be that you know, they shouldn't transfer anyway. Sometimes we've seen files where there's sort of scant information, and we're not really filling out very many boxes, and we're saying that the firm hasn't captured enough information, but there's real sort of indications on file that the client doesn't have the right attitude to transfer risk. So whilst the firm shouldn't have gone ahead and made a recommendation, we can still assess that perhaps that wasn't the right thing for that customer to do, because they could never really sort of, you know, stand the risk of transfer. Income and expenditure are a couple of sections, and it's the income and expenditure sections that seem to have the least amount of detail, where actually it should have the most amount of detail. When we read through the guidance manual and we look at the tool, it's important to point out that we can infer certain information. So where, for example, a client is very close to retirement and we've got current expenditure, but we don't have retirement expenditure, we can infer certain things, especially if we can see, for example, a mortgage might be paid off, or you know, there's indications that the client might want to travel more, or whatever it might be. So we can infer certain information, certainly around state benefits. So we might not have any idea around state pension entitlement, or there might not be details, or certainly BR19 on file. But if we can see a client's employment history and sort of make a reasonable guess as to what their entitlement might be, we can include that. And in fact, the tool does ask for us to specify whether it is, you know, an actual forecast or something that we sort of estimated. We can infer other information as well around the client. So if there was nothing to suggest any vulnerability, we can infer you know, that there isn't. If there's no information on sort of ill health, we can infer that the client is in good health, you know, tax status, that sort of thing. And it's a bit of a judgment call throughout, really. The tool then goes on to collect information about the seeding scheme and receiving scheme, and then the associated transfer analysis. As we know, especially now, receiving scheme details are important, and the advisor needs to know where a transfer will be going in order to give this advice. So what this tab does really is it forces the reviewer to make a determination of suitability, and whilst the tabs are sort of quite sequential, the subsequent tabs do have a bearing on the first tab. So it's really on this tab that we'll be having an idea about whether we think this advice is suitable or not. And in conclusion, at the bottom of this tab, the reviewer will be detailing all of the information that was perhaps missing, what the significance was of that information when assessing suitability, and whether or not that missing information was material enough to stop an assessment.
Presumably also, if you've been inferring things as you've been going along, capturing what you've inferred and on what basis is also very, very important.
Yeah, absolutely right. And what the instruction manual does is it provides all of the different COBS rules that apply to all of the different sort of aspects of this tab. So when we're writing up the summary as to where perhaps the firm has failed, we'll be citing the actual COBS rules as to where failures have taken place, if they have. Yeah. So once the reviewer or the advisor has gone through, ticked all the yes nos, the tool itself will come up with a preliminary assessment based on the yes nos, which will either be compliant, so all information is there and we can proceed to a suitability assessment, or it will be no, there is some missing information, it's not compliant, it's unclear, we can't really go ahead and assess, we don't have enough information to either make a determination at all. Or interestingly, we could say that it's not compliant, there's some missing information, however, that missing information isn't really material enough to stop us going ahead and making an assessment, because having looked at the case in the round, our assessment is that the advice to transfer isn't suitable. So the example I gave around attitude to transfer risk, for example.
Yeah, so it almost doesn't matter what more there is out there. It is overwhelmingly unlikely that anything could materialise that would make this advice suitable.
Precisely. So we could have missing information on spouses, income and expenditure and financial situation, whatever it might be, but actually it's quite clear to us that this client can't sort of stand any risk of transfer, haven't got the right attitude, it's not going to be the right thing. So notwithstanding missing information on the spouse, we can go ahead and assess that the advice to transfer was unsuitable. So that's sort of the first tab in a nutshell. And it's sort of worth pointing out that when we're talking about the necessary information to make the personal recommendation, we need to consider whether it's the client's circumstances that mean that the collection of information hasn't been possible, not the advisor. So, if a client can't provide certain information and there's valid reasons for that, or it's not important, that's fine. But, it's not quite an excuse for the advisor to sort of, we haven't got time to gather all this information and have another meeting with your spouse or whatever it might be. We need to do this, now. That's not a reason for sort of a justifiable reason for having missing information. So that's the first tab. As I said, it's the most tricky, and from this tab then we sort of move on to assess suitability. So if we could, thank you. So the first then tab is assessing the pension transfer suitability. So we're only looking at pension transfer. We're not looking at any receiving scheme, investment advice type issues here.
That comes later.
That does come later. And I think we've seen in the past where transfers have taken place, but perhaps it hasn't gone to the most appropriate receiving scheme, advice has been deemed unsuitable in the past because they're sort of looking at everything in the round. So here we're just looking at pension transfer. And really this tab is, she says, one of the most straightforward in that there are some examples of unsuitability given that the FCA has sort of cited, sort of 11 or 12 reasons or examples of unsuitability. And when going through this tab and looking at assessing the file, what the reviewer should really be doing is sort of taking into account the client's intentions for accessing the pension benefits, what their attitude is, and understanding of the risk of giving up safeguarded benefits for flexible benefits. So sort of attitude to transfer risk type questions, what the client's attitude to an understanding of investment risk might be, the client's realistic retirement income. This is where we see firms really fall down, but it's really looking at what the retirement income need will be, how that can be achieved, the role that this scheme will play in meeting those needs, and then the constant impact of any transfer. And this is where really we expect to be seeing evidence of trade-off conversations, you know, between the advisor and the client. And then alternative ways of achieving client objectives. Often we see clients coming in, you know, wanting flexibility. Okay, let's transfer. Whereas, you know, in actual fact, flexibility could be achieved in other ways. You know, perhaps there's other DC pots lying around. You know, perhaps they could take early retirement if that's necessary. You know, they might have other assets that they can use. So we don't often see alternatives really explored in the way that they should. And as we go through considering all of these sort of aspects, the advisor and the reviewer really just needs to fairly consider and give appropriate weight to all of the client information on file and all those different aspects. And depending on the client and depending on the client's circumstances, you know, different weight will be given to different aspects of the file in different cases. You know, and that's where the sort of subjectivity and I guess experience and expertise really does come in. So then it will be a case of determining whether there are examples of unsuitability present. And so some examples of that might be, as I said, the client wants flexibility, but perhaps the firm hasn't demonstrated exactly why a client needs flexibility, or why it would be in their best interest to transfer in order to achieve this flexibility that actually might not even really be a requirement.
Yeah, we see this a lot, don't we? You know, the flexibility cited as an objective, but with a lack of real client-specific depth or description on, you know, what does flexibility mean for that particular individual?
That's right.
And why do they need it? Why is a regular steady income from a scheme not appropriate for them?
Yeah, absolutely. And if flexibility is a real desire, is it really worth giving up safeguarded benefits in order to achieve that flexibility? And that's where we'd expect sort of, you know, the trade-off conversations to really come in. One of the main or sort of the key areas when looking at examples of unsuitability is the client's reliance on income from the scheme. So that's sort of the very first question, the very first hurdle. And again, as I said, you know, it depends on different client circumstances. You know, for some, the scheme will be a very small proportion of their retirement income. For others, it will be, you know, their sole retirement income. And whilst there might be real heavy reliance on the scheme itself, that's fine. That doesn't automatically sort of exclude any sort of justifiable reasons for transfer. You know, if it turns out that a transfer takes place, but there's going to be, you know, sort of quite limited reliance on drawing from that pot and other justified objectives can still be met, then, you know, we might say that the client is reliant on income. So that is an example where unsuitability might be present, and we would answer yes on the DBAT tool. We can then sort of override that as we go further down the tool to sort of say, you know, reliance was an issue. However, you know, this transfer is justified and, you know, reasonable and within the client's best interest because of X, Y, Z reasons. So it's all about really sort of justifying what's been done and why. So as I said, it's sort of determining whether there are examples of unsuitability present, and then deciding with reference to the examples whether or not you know, the firm failed to comply with suitability requirements.
That's a good question. So if there are any indicators of unsuitability present, does that automatically mean that we have to judge the advice to be unsuitable? No,
it doesn't. It might be that, you know, that it is unsuitable because of one of those examples, but if, for example, I don't know, reliance on income, for example, is there, but actually they can still meet their income needs by transferring, and there is a real, you know, sort of documented need for flexibility. You know, control is, you know, we don't often sort of give much weight to control, but flexibility might be a real reason, and inheritability, you know, it could be that somebody single, they don't have a spouse, they don't have, you know, any sort of dependents that would benefit from the scheme, but they think it's unlikely that they're going to sort of, you know, use the pot, and they are really keen that it, you know, goes to wherever they want it to, then that's fine. It could be that the client doesn't have the right attitude to transfer risk, but actually one of the reasons for transfer is real financial distress, and their home is about to be repossessed or something like that. So there can be examples, but they can be overridden if perhaps other objectives are more important and can really be achieved by transfer. So we often
those indicators in the tool might suggest
yes.
a suitability determination, but they don't mandate one. You've got to apply your experience and judgment to the particular case.
Precisely, which when I go back to, the tool doesn't determine the outcome. It will give, you know, a preliminary sort of assessment, but then it's for the reviewer to decide and override where appropriate. Yeah. And I think, as I said, when we started using this tool, you know, in detail for the first time, you know, I think we failed all of the cases that we reviewed. They were all unsuitable. But actually, sort of as we sort of go through and sort of have some trade-off conversations, not necessarily going back and sort of re-advising, as we sometimes were sort of doing. Yeah, you can sort of make some determinations and make some judgments and say, you know, whilst this particular sort of example of unsuitability might be there and it's not fully demonstrated why it was the right thing to do for that particular reason, because of other objectives and other real sort of justifiable reasons for transfer, then, you know, that's okay and we can square that off.
Yeah.
So that's the first sort of assessment tab. So that's pension transfer suitability. And then we move on to the investment advice tab. So very similar to that of the pension transfer, other than we have already decided about pension transfer suitability and we're not reassessing pension transfer suitability when we're looking at investment advice. So if the transfer was the right thing to do, then now we're looking at whether or not, you know, the money has been invested in the right way for that client. And what we need to be taking into account here is what the client's investment objectives are. So that's, you know, attitude to risk, how they intend to access the funds and when, you know, whether or not they need to be keeping money aside to access for tax-free cash. We're looking at their ability to bear the risk associated with the transfer that is consistent with their own financial objectives. So that's important. And the client's ability to understand the risk associated with the proposed arrangements. And this goes back to what we talked about, knowledge and experience. You don't have to have experience of having made a transfer in the first place, you know, another DB transfer in order to have experience of this, but if you've got experience of managing, whether it's other pension savings or investment savings. And then we also need to take into account any information that they've been given over the course of their dealings with the firm. So it is quite possible for a client to have no real knowledge or experience, but for the firm to impart their knowledge and experience onto their client and to raise the level of knowledge within that client to enable the client to be in an informed position, sort of understand what they're doing and why they're doing and whether it's the right thing for them. Charges play a part. So, you know, examples of, you know, a pension transfer might be the right thing, but we might fail investment advice if, for example, a client might have quite straightforward needs, but they're invested in, you know, either funds that aren't aligned with their ATR, or they've been put in sort of several layers of wrappers. You know, they might be in a, you know, a SIP and a DFM service and other ongoing service that they don't really need. So potentially duplicating charges is what we might see there. And then whether or not, you know, even though it's an explicit rule now, but, you know, even prior to the explicit rule, whether or not there was, you know, other low cost alternatives available. So has an advisor considered a workplace scheme and if not, why not? And if there's no sort of justifiable reason as to why they haven't considered the workplace scheme, it could be that might be an example of unsuitability present. Depending on how material that is, will determine whether or not we sort of make the whole investment advice suitable or unsuitable. One of the key, in our experience, the main reason for failing investment advice suitability is where 100% of transfer has been fully invested without allowing for tax-free cash. That much. I think the FCA's real concern here is where, you know, transfers are made into sort of scam type investments, or, you know, high risk uses type investments, or, you know, the Chilean copper mine type scenarios. So that's what we're really looking at here. But essentially how we view this is looking at that pot, that transfer money, the CECB, as a pot of money that has come to the client, you know, as a windfall or an inheritance. So, you know, we're not sort of, the fact that it's come from a pension at this point is irrelevant. We assume it's come from a DC type arrangement when assessing this. So again, we sort of go through tabs, tick the yes or no's, whether or not the examples are present, and then, you know, the conclusion is to justify why it is or it isn't suitable or not.
And again, we're separating out the two assessments of pension transfer advice and investment advice, and it's perfectly possible for the pension transfer advice to be suitable and the investment advice to be unsuitable, or indeed vice versa.
Indeed, yeah. So we can have examples where pension transfer is unsuitable, but that notwithstanding, it's unsuitable, but actually where the money's ended up is in the right sort of destination scheme for the client. And then I think that really, where this plays out really is when we sort of look at redress and the different sort of redress calculations that might take place depending on where there is sort of unsuitable advice.
Yeah.
So that's that tab. The next tab is really looking at the insistent client process. So this will be for firms who follow an insistent client process, and therefore whether or not they follow it within the rules or not. So what this tab allows us to do is to identify firstly whether or not the client is insistent. And it's important to point out, we don't mean the client being insistent on a course of action. So I go to the advisor and I'm insistent on transferring, all my friends have transferred, I'm hell-bent on transferring, that's what I want to do. And the firm goes ahead and makes a recommendation to transfer. That's not what we mean. We mean where, you know, a client is insistent on a course of action that goes against the recommendation that they've been given by the firm. So that's important. So then we sort of go ahead and look at, this is sort of looking at advice process type failings really, and determining whether or not the firm has provided the necessary information to the insistent client, and whether or not the firm has obtained acknowledgement from the client that the client knows that they're acting against advice and why they want to act against advice, and then has the firm sort of provided the client with, you know, a further recommendation, or really sort of detailed out why their first recommendation was the right one, and, you know, that the client knows that they're acting against advice. And it's important then, especially from January 2018, that the firm makes a record and keeps details of this process. You'll see here that the ratings are back to compliant or not compliant. So this is again whether or not the firm is compliant with COBS rules or not compliant with COBS rules, similar to the first information tab, which was a compliant or not compliant rating. So that is not compliant with certain COBS rules, as opposed to the two previous slides, which the ratings are suitable or unsuitable. So that should help us really understand what bits of the tool are sort of advice process type failings as opposed to advice failings. So insistent client tab forward. Disclosure tab, again, now we're back to sort of compliant or not compliant disclosure. This tab can take us quite a long time to complete. It can be quite arduous. There's quite a lot of sections in here, but the disclosure is broken down into sort of services and cost disclosure. So, you know, IDD and SDD and all of that, fairly straightforward. and then whether sort of the right product disclosures have been given to the client. Where we probably fail quite a lot here is on the suitability report disclosure. So this goes back, Peter, to what you mentioned before about, perhaps misleading comments in a suitability report. So whereas we might have rated the advice to transfer to be suitable, but there are some real horrors in the suitability report, where they're not material to the advice that was given or material to the assessment, this is where we'll raise, for example, misleading statements. There could be misleading statements about PPF or about the ability or inability to retire early. Those sort of statements that we might pick out where suitability reports might be really long and wordy and confusing, or might not actually really stipulate why the advice is to transfer and how it meets the client's needs and objectives. All of that sort of gets picked up here in this disclosure section. Similarly with sort of TBC or TBAS type disclosure. So we've seen, especially prior to reviewing advice with the DBAT tool, where the TBC or the TBAS might not have the right retirement ages, or they might not have accounted for early retirement, and might not have all of the information. Where there are failings in sort of the analysis that are, I guess a function of poor process, we'll pick that up in the disclosure tab. If there's anything that is material to the advice itself, that will get picked up in the suitability tab. And one of the examples is there that the TBAS or the analysis doesn't support a recommendation. So
again, this is helpful for them to separate it out. You can assess the transfer advice in and of itself, and at this point you're thinking, well, okay, I don't like what's in that suitability report, but it either is or is not material to the advice. A disclosure failure might be so egregious that it makes some advice unsuitable because it sort of advises the customer through a course of action that really is not appropriate for them, or represents that course of action in a completely misleading way. But it's helpful for us again to separate them out, because you can say, well, okay, ultimately the outcome was okay, but I've got some challenges and some issues to address on updating our TVCs properly, or the contents of suitability reports.
Yeah, absolutely. So a prime example might be some sort of misleading or inaccurate comments in the suitability report about an ability to retire early. And if that is a client's sole reason for transfer and the sole basis upon which a recommendation to transfer is being made, but the client thinks the only way they can achieve their objectives to retire early is by transferring, then we might consider that material to the advice. It would be material to the advice. So we'd pick it up in disclosure, but it would also be picked up in the suitability assessment. In work we've done with firms, we also find that the disclosure tab, as well as the information tab, are probably the two most important tabs when providing compliance with information about what their advice sort of force is doing, and actually can really sort of help with training and correcting process procedures failings. And so whilst it might not have an impact on the suitability assessment, it's actually really key for firms to take notice where there are disclosure failings to really improve their offering to clients.
Yeah, it can be a bit of a near miss, can't it? The ultimate outcome was probably okay for the customer, but the way it was presented risks potentially harm to them. Yeah,
I mean that's where we sort of see examples of suitability by accident. So it could be the client's circumstances and financial situation mean that, even a real, horrific job of advice, it was always going to be the right thing to do to transfer, for example. So conscious of time, that's disclosure. The next tab, causation. So this is once we've established that there has been some, erroneous, poor behaviour by the advisor, and they've advised the client to do something that they shouldn't have done, whether it's in terms of pension transfer, investment advice, or even disclosure failings. This is where we're looking to sort of assess whether or not it's more likely than not that the firm's non-compliant conduct has caused the client to take the action that caused them loss. So once we've established that the transfer was unsuitable, let's say, and we've established that there was a loss associated with that poor advice, this is when we're sort of into the legal world now, really, around causation and whether or not redress ultimately gets paid out. And this is where
I always think of this. In other words, the advice was poor, but for some reason the advice was not the immediate proximate cause of the customer taking the action that they did.
Yeah, exactly. So yeah, so we've seen somewhere, you know, a client is absolutely adamant on a course of action because their pals have done it and they were going to do it regardless of the advice. We've seen cases where advice has perhaps been given to financial services experts or specialists. So we've seen advice given to pension transfer specialists or, you know, financial professionals, whereby irrelevant of the advice that's given, the course of action was going to be taken nonetheless. But in order to come to this determination, there needs to be some really sort of compelling evidence on file to suggest that this client was going to take that course of action. And then we wouldn't ever really sort of go ahead and say the causal link was broken without having customer contact. And in fact, we have reviewed thousands of files, and I think I could count on one hand how many have sort of been ruled out on causation. But it's there nonetheless. And that's pretty much it. So that's sort of a quick run through. As I said, it's taken us quite a long time and a lot of use and experience to get to the point where we're quite comfortable using it. So sort of 45 minutes probably doesn't do it that much justice, but I hope it's provided a bit of insight.
Yeah, thank you, Rebecca, for taking us through that, imparting your experience. Much appreciated. We've got time for some questions now before we close. So I'll invite those again. I can't see any at the moment. Okay. Let me ask you a question, Rebecca. So I can imagine there are lots of people looking at this and thinking to themselves, goodness gracious me, that looks complicated and very involved. You know, how long does it take typically to use this tool to get from one end of an advice review to another?
Well, that's a good question actually, and you know, our timings have sped up, I guess, with experience. We tend to estimate or average 1 day per review. So obviously that would be quicker if you were using it when giving, you know, real live advice, or perhaps doing a compliance check if you wanted to just use it as a checklist. Yeah. But in order to review all the documentation on file, because it's worth pointing, when we're filling out the first tab, we'll be getting information from fact find and suitability report, but there might also be information hidden in emails, other correspondence, other files, spouse files, for example, yeah. Or files that were where advice had been given a year before, perhaps on a different aspect. What we're essentially looking at in that first tab is what information did the advisor have. So it might not have been documented on a fact find, but it might have been there because it's on other previous pieces of advice. So it can often mean trawling through quite a lot of information, certainly trawling through, you know, seeding and receiving scheme and sort of analysis type documentation. But yeah, we average about 1 a day, I think.
Yeah, that's the other thing I was going to ask you. How would you adapt? Because that is quite an involved process if you're retrospectively looking at every aspect of this piece of advice. So how would you adapt its use to be quicker, particularly if you wanted to look at some advice that's being given right now? So if you're doing some pre-sale checks, for example.
So if you're doing pre-sale checks, you probably wouldn't have to spend a lot of time on certain aspects of the disclosure tab. You know, provide the provision of, you know, disclosure documentation. If you know your suitability reports and the templates that you use and the wording that's used, and you would sort of know that there shouldn't be any sort of misleading or inaccurate comments in the suitability report, you might not really have to spend too much time on that part of the tool. I would use it pretty much to see, has all of the relevant necessary information been captured, and then does it stack up, and is there real sort of justification for the transfer? And if that justification for transfer is really there, you know, it should be quite straightforward. And if you're doing it for your own sort of sales forces, you know, you'll know your procedures, you'll know your suitability, you'll know where to find certain documentation. I mean, sometimes we're the firms where we haven't seen their fact finds or their suitability reports, or we're not familiar with their cash flow modelling sort of tools and things. So you should be able to use it a bit quicker if you're giving live advice.
So you could use the information tab as a sort of a checklist of has the advisor gathered and analysed everything that is needed to give this advice compliantly. Yeah,
exactly.
We've had an interesting question coming, Rebecca. Yeah, actually, this might be just to touch briefly on what to do in unclear cases, actually. But the question is, can retrospective action ever change the result of a DBAT appraisal, the pension transfer advice outcome?
Interesting question. So on the first tab, when we've got unclear cases, so there's just not enough information for us to assess whether or not it was the right thing or not. Or sometimes what happens is there's some missing information that we think would actually make the advice to transfer be suitable, but it's just not there. We can't, we can't sort of hang our hat on something that's not there. So we do undertake client contact exercises where we will speak to the client. We are looking at what happened at the time of advice, and so all evidence needs to be, contemporaneous. But we will have conversations with the client, taking them back to that time and asking some questions, perhaps, which might fill in missing gaps that we can then detail on the file, and then sort of go ahead and perhaps make our assessment as a suitable outcome.
Yeah. So it is perfectly it's a perfectly legitimate course of action in the case of where the advice simply isn't clear, or we haven't got everything that we need to intervene to approach a client, perhaps. We're looking at your advice. Can you fill in these gaps for us? What were you thinking at the time? Have a conversation which can help you to reach a suitability determination. It's perhaps trickier to intervene where you don't need to do that, and you think, looking at what's here, the advice was unsuitable.
Yeah, absolutely. I mean, where we've assessed advice as unsuitable, we've done it with firms, and firms might have challenged our assessments. And then say, well, we've got this information that we found on file that you weren't aware of, and we can then sort of go and reassess additional information that would have been available to the advisor at the time, and if that has a bearing on our outcome, then that's fine.
Yeah, good. Okay, thank you for the question. I'm conscious of time, so I think we should close down now. So our contact details are on the screen. As mentioned earlier, we'll send out a follow-up email with a recording of this event to everybody who registered, and I think we're showing as well some of our other upcoming events as well.
Yeah.
So firstly, next week's session, so the final virtual session in our series, Rebecca and I are going to talk about the components of high quality, compliant, in the eyes of anybody who's interested, DB transfer advice. Focusing on the APTA and other things.
Yep.
And then there are some other upcoming events on other subjects. The consumer duty, we touched on that last week actually. The consumer duty sort of overarches everything that's going on really in an FCA regulated world if you have retail clients at the moment. So we've got some events about that as well. So Rebecca and I look forward to seeing you all next week. If you can make the time to watch our webinar next week, either live or a recording. Thank you once again for joining us as we approach 11 o'clock. And we look forward to seeing you next time.